Criminal defense attorney Arthur Aidala. Great to have you back, as always. All right, so what did you make of Stormy Daniels' testimony?
Well, first and foremost, from a legal point of view, she's really not necessary. She doesn't have any of the keys to the castle, so to speak, for the prosecutor. They don't have to prove beyond a reasonable doubt they had sex. They don't have to prove beyond a reasonable doubt that they even knew each other. They have to prove beyond a reasonable doubt that the checks were cut, that it was decided to put it in the book improperly, and then or like label it inaccurately, and that was being done for election law fraud. So had they not called her, it wouldn't have been like a mistrial. It wouldn't have been like, it was out of the question. But they did call her. And, I have a colleague who was in the courtroom. They said initially she was going a mile a minute. The judge told her to slow down. The prosecutor told her to slow down. She was so nervous. And for a woman who had the profession that she did, where a lot of people were watching her do very intimate acts, for her to be now in this environment, to be that nervous, that raises eyebrows. And that's something I would bring up in my closing argument as a defense attorney. The defense attorney on President Trump's team, who's cross-examining her, Susan Nicholas, is someone I know well for a long time. She's spectacular. And on Thursday morning when they return to court, you're going to watch her kind of dissect every piece of the story. But really, Linsey, all the prosecutor really needs to get out with Stormy Daniels is, yep, we had sex, and that's one piece of it. And I think she's going to make that point. And then the time after the Access Hollywood tape came out, there was frantic negotiation to enter into, the proper word is, phrasing is a non-disclosure agreement. There's no hush money agreement. It's a non-disclosure agreement, and that's the terminology she used.
And would you say she's now violated that?
Yeah, isn't that funny? I don't exactly know what the terms are, but it's usually 3 times the amount of what the payment was. But Donald Trump technically is the beneficiary of the non-disclosure agreement, and because she violated, she probably owes him, I don't know, $390,000, something like that.
So you're saying you don't think that the testimony about the sex was necessary, the alleged sex, I should say. Why do you think it was important for the prosecution to have her lay out detail after detail?
I think 2 reasons. Number one, to complete their narrative. And number 2, imagine if the argument by the defense team was this never happened and he was just paying money for nuisance money so someone didn't tell lies about him, much like the doorman who said he had a child out of wedlock who they paid money to. You're going to get a lot more sympathy from a jury saying, wait a minute, this woman was just shaken out. It was pure extortion. She made up a story out of whole cloth and wanted money. So I think they needed to check that box from a common sense point of view, but the judge is not going to charge them. And if the prosecutor proved beyond a reasonable doubt that they did have sex, you can find him guilty. They're never going to hear that from the judge.
So the defense, obviously, they are calling for a mistrial. The judge denied that, but they said that this testimony was extraordinarily prejudicial. Do you think it was?
I don't think it was that prejudicial. Whether it was necessary, whether it's relevant, legally, it's not really relevant. It's not there to prove a material fact that the prosecutor has to make to prove their case beyond a reasonable doubt. I will tell you, though, Linsey, I think this is the first time they moved for a mistrial in this. I think we're on the 11th day. Had I been trying this case, they would have been, without exaggerating, every day I move for a mistrial. I find some reason, because the only thing you have as a defense attorney is your record, and you have to protect it at all costs. And there's no better way to move for a mistrial to protect your record than moving for a mistrial. And in fact, when they moved for a mistrial, the judge criticized the defense team, saying, well, you were barely objecting through her direct testimony.
Arthur Aidala, always appreciate your expertise and insight. Thank you so much.
Thank you so much.